Hello and welcome to Bar 10 Test Prep, where we help you prepare for the bar exam 10 questions at a time. We upload content every day, so we ask that you like, subscribe, and ring the notification bell so you can be updated every time we upload new content. Let's get right to question number 1. A creditor instituted a garnishment action against a man who owed the creditor a back due debt. This was the first action taken, and the creditor did not have a judgment. It served the notice of garnishment on the garnishee, which was the man's employer. The employer honored the notice of holding all of the man's earnings in escrow pending the creditor's lawsuit and entrance of final judgment against the man. The state where defendant lived and worked had a provision for pre-judgment garnishment, as long as the money was held and not distributed until a judgment was in fact entered. The money would be paid to the man if a judgment was not entered within the next 120 days. The man sued the employer and the creditor, demanding release of his earnings. Will the court order the garnishee to release the funds to the man? You have 4 options as possible answers. A, no, because the state has an interest in protecting the rights of the creditors to collect debts through the garnishment procedure. B, no, because the state procedure for protecting the man's money until a judgment is entered is a fair one that comports with procedural due process. C, yes, because the interim freezing of wages without a chance to be heard violates procedural due process. Or D, yes, because the only party that has garnishment rights in the United States is the Internal Revenue Service. You have 10 seconds to answer this question. The correct answer here is C, yes, because the interim freezing of wages without a chance to be heard violates procedural due process. Let's look at the 3 others. A, no, because the state has an interest in protecting the rights of creditors. That's where we stop. Generally, the greater interest is on the rights of the citizen as opposed to businesses or the creditors. B, no, because the state procedure for protecting the man's money until a judgment is entered is a fair one that comports with procedural due process. Not sure if your thoughts are the same as mine, but generally ignoring due process is usually not a very good protection of it. D, yes, because the only party that has the garnishment rights in the United States is the Internal Revenue Service. We know that to be inaccurate because courts order garnishments of wages on a regular basis on issues such as child support and other types of cases. So the only correct answer here is C. Let's move on to question number 2. Carter, a current drug user under treatment, seeks employment at a local state-run facility and is denied employment based on, he believes, his status as a drug user. As state has a regulation in place keeping current or former drug users from employment in state-run facilities as a protective measure. If Carter is accurate, please describe what level of scrutiny the court would use in reviewing his case and the regulation in question. A, strict scrutiny, since drug users are a special class of persons often discriminated against by the public. B, intermediate scrutiny, because like gender, this can be a sensitive area where discrimination is common. C, the rational basis test, because discrimination is generally favored with drug users or even those getting treatment. Or D, the rational basis test, because the regulation need only be related to a legitimate state interest to be valid. You have 10 seconds to answer. The correct answer here would be the letter D, the rational basis test, because the regulation need only be related to a legitimate state interest to be valid. Question number 3. The owner and sole stockholder of a small business negotiated to sell the business to an individual investor. The parties met and signed a letter agreement which set forth the price, down payment amount, financing terms, the assets to be included, and a host of other pertinent details. The final closing date was not stated, but the purchasers left a down payment of $45,000 with the seller. The letter stated that the terms comprised their essential agreement and that a formal document would be drafted by the parties' attorneys. Before that happened, the seller returned the check and refused to perform. The investor bought an equity action for specific performance to compel the sale. The equity court ruled that there was a complete and binding contract that must be specifically performed. Will the appellate court likely affirm the lower court's decision? We have 4 options. A, no, because the closing date was left out and the attorneys were supposed to compose the final contract with all the remaining details put in. Option B, no, because the type of letter is basically a gentleman's agreement that is not intended to be legally binding. Option C, yes, because a letter of intent is legally binding if it sets forth the price, describes the business, and is signed by both parties. Option D, yes, because where the letter contains all of the essential terms required for a contract, it'll be enforced as a contract. You have 10 seconds to consider your answer. The correct answer is D, yes, because where the letter contains all of the essential terms required for a contract, it'll be enforced as a contract. Where the parties have settled upon the essential terms and the only remaining act to be done is the formalization of the agreement, the latter is not inconsistent with the present contract. That's from Field versus Golden Triangle Broad. Let's look at the three other options. No, because the closing date was left out and the attorneys were supposed to compose the final contract with all the remaining details put in. I think ultimately the court will see this as fluff, and the fact that they're adding in or formalizing an agreement that's already been signed is really just, in essence, just that formalizing, not an action, not the actual agreement which occurred at the initial signing. B, no, because this type of letter is basically a gentleman's agreement that is not intended to be legally binding. Based on the facts, I don't believe this is accurate. It seemed as if all of the terms were in fact negotiated, and the only thing left was to agree upon a closing date to formalize this agreement, which had already been signed. C, yes, because a letter of intent is legally binding if it sets forth price, describes the business, and is signed by both parties. Generally here, we're looking at a letter of intent as opposed to an agreement itself. While C would seemingly be correct, the fact that it mentions a letter of intent is in fact a significant distinction, which causes D to be the best answer. Let's look at question number 4. Jay was pulled over by police for speeding. On being pulled over, the officer believed Jay to be acting strange and with no articulable or specific reason searched the vehicle and recovered a crack pipe. Jay was arrested. At trial, Jay's counsel now moves to suppress the evidence based on a bad search. Would the motion likely succeed? A, yes, because the search was unconstitutional due to the officer having no probable cause that would justify searching the car. B, yes, because when a car is pulled over for speeding, the officer must always obtain a search warrant prior to making any search. C, no, the stop and search were within the normal bounds of propriety for a speeding stop. Or D, no, because driver being fidgety is enough for a probable cause full search of the vehicle. You have 10 seconds to consider your answers. Correct answer is A. If you chose A, good job. Yes, because the search was unconstitutional due to the officer having no probable cause that would justify searching the car. Let's look at options B through D. B, yes, because when a car is pulled over for speeding, the officer must always obtain a search warrant prior to making any search. That is wholly inaccurate. One, we have the plain view doctrine, where if something is in immediate sight, obviously the officer can reach for it, can grab it, can arrest based on it. Secondarily, the officer must not require a warrant in order to search a vehicle if he has probable cause to arrest for any other basis. So if he has probable cause to arrest, that carries with it the ability to search the vehicle as well. C, no, the stop and the search were within the normal bounds of propriety for a speeding stop. That's inaccurate generally. If we're looking at Terry stops in those situations, the initial levels permit communication and permit nothing more unless there is something which causes the officer to believe that he has cause to search. Here, there's no cause which is mentioned, other than for no articulable or specific reason the officer conducted the search. That would not suffice. Option D, no, because driver being fidgety is enough for a probable cause full search of the vehicle. I would present that's inaccurate, and 2, it's also not stated within the facts other than the J was acting strange. I'm not certain what that means, but acting strange generally does not give rise to the level of a full search of the vehicle without other cause. Question number 5. Defendant charged with rape wishes to present evidence of victim's promiscuity by way of testimony of several sexual partners. Would such evidence generally be admissible? A. Yes, because the rules permit evidence of a victim's sexual predisposition to test credibility. B. Yes, because the evidence will help the jury see there may be two sides to the story and that the woman was thus the sexual predator instead of the man. C. No, because such sexual predisposition evidence is generally prohibited by the rules of evidence except under narrow exceptions. Or D. No, because the rules of evidence prohibit all evidence of a victim's prior sexual history. 10 seconds. The correct answer here is C. No, because such sexual predisposition evidence is generally prohibited by the rules of evidence except under narrow exceptions. Federal Rules of Evidence 412 prohibits evidence of sexual predisposition and of prior sexual activities. As a result, I think that would be directly applicable here, and Rule 412 would in essence not permit this type of evidence to come in. Question number 6. Defendant makes a motion under the best evidence rule seeking to exclude testimony on the results of a medical exam, an MRI, by a medical technician. Defendants claim that the testimony is improper and the actual test results should be introduced. How should the court handle this motion? A. The witness does not have to produce the MRI scan because a layperson can testify to things of common knowledge, such as what a sponge looks like. B. Witness does have to produce the MRI scan because a layperson cannot testify to personal observations. C. Witness does not have to produce the MRI scan because she can testify to the content of her own medical records. And D. MRI records must be produced because they represent the best evidence under the best evidence rule. You have 10 seconds to consider your answer. The correct answer is D. MRI records must be produced because they represent the best evidence under the best evidence rule. The best evidence rule applies where a party attempts to introduce outside evidence to prove what the contents of a document are. Under Federal Rule 1002, also see Doe versus U.S. Let's look at the other three options. Witness does not have to produce the MRI scan because a layperson can testify to things of common knowledge, such as what a sponge looks like. While that may or may not be accurate, truth is here that the results of a medical exam are not only determinative on a injury type of case, or in many cases where such evidence is presented. The issue here becomes that the layperson cannot generally testify to a result, or at that point it would be an opinion. The opinion would be, in essence, irrelevant. B. Witness does have to produce the MRI scans because a layperson cannot testify to personal observations. That is contradictory to A, and generally, while that is true, there are certain circumstances where a layperson can, in fact, testify to their personal observations. That is called an eyewitness. C. Witness does not have to produce the MRI scan because she can testify as to the contents of her own medical records. Bit tricky here. If we look at the question notes that this person is a technician, not a medical provider. Generally, a technician does not have the ability to provide medical advice or to give medical advice or to give an interpretation on medical advice. As a result, D would be the only correct answer. Let's move on to question number 7. The owner of a hookah lounge found themselves in a predicament where they opened the store without reviewing local ordinances, which prohibit the opening of such a shop at the location where the shop was to be opened. Owner moves before the court to invalidate the restriction as a preemptive violation of his due process rights. Will the prohibition likely be enforced? A. Yes, because the owner was not treated differently than any other store owner. B. Yes, because the correct test requires only that the law in question satisfy any set of facts that could establish a rational basis for achieving legitimate government ends. C. No, the owner has a vested constitutional right to earn a living, and that this unreasonably precluded by the law in question. Or D, no, because this ordinance is so individuously discriminatory that it must pass the strict scrutiny test, which it fails to do. You have 10 seconds to consider your answer. If you chose B, you'd be correct, yes, because the correct test requires only that the law in question satisfy any set of facts that could establish a rational basis for achieving legitimate government ends. Social and economic regulations generally subject to this rational basis review, and is therefore afforded a presumption of validity. So here we, without question, given the fact that the regulation would be presumed valid, I'm not certain that the hookah lounge owner, given the fact that he made an error and did not seek out the regulations applicable, would have the ability to overturn this regulation. Question number 8. 5 men together stole a vase from an art museum. One of them, who was the driver, was caught during the commission of another crime. He told police, "I didn't even get any money from the art museum. It all went to the first guy and the second guy." When the first and second guy go on trial for the theft of the vase, is the driver's statement admissible in court? A, yes, as an admission by a party opponent. B, yes, as a statement against the interests of the other defendants. C, no, because it was made while in custody and therefore unreliable. Or no, because the statement was not made in the course of or in furtherance of the conspiracy and thus it is hearsay. You have 10 seconds to consider the answers. The correct answer here is D, no, because the statement was not made in the course of or in furtherance of the conspiracy, and thus it's considered hearsay. The statement is hearsay because the co-conspirator did not make the statement during the course of the conspiracy. To establish a foundation for admission of evidence under the co-conspirator exception to the hearsay rule, the government has to show 1. The existence of a conspiracy. 2. The statement was made by a co-conspirator of a party. 3. It was made during the course of the conspiracy. And finally, 4. It was made in furtherance of that conspiracy. Here, we have an issue of timeliness. The temporal issue leads us to, given the fact pattern, to see that the statement was actually made significantly subsequent to the conspiracy and during the commission of a different crime and the processing for that crime. As a result, the statement would be deemed hearsay and would be inadmissible. Question number 10. Owner owns a small service business. He secures the services of his assistant to appear at a convention on his behalf and gives her business cards and many other bits of information to disseminate to parties at the convention. While at the convention, an employee is approached by a registered guest and proceeds to offer specific items for resale at owner's shop. Employee agrees on behalf of owner. Upon completion of the convention, owner and employee discuss what occurred, and owner is informed of the deal reached between employee and guest at the convention. Owner takes no steps, and upon attempts to enforce the agreement by guest, owner rejects the agreement. Guest attempts to enforce the agreement. Is the agreement in fact enforceable? A, yes, because the furnishing of the indicia of authority to act to the employee was sufficient proof to bind the principal. B, yes, because the principal is bound to the employee's actions whenever he sends an employee to attend a convention on his behalf. C, no, because the technological revolution makes it easy these days for a potential customer to first confirm the existence of actual authority. Or D, no, because people dealing with an assistant at a convention have a duty to determine whether that person is in fact an authorized agent. You have 10 seconds to consider your options. Correct answer is A, yes, because the furnishing of the indicia of authority to act on behalf of employee was sufficient proof to bind the principal. Apparent authority exists where a reasonable person would understand that the assistant had authority to act. Here, given the assistant's materials to set up an official table at the convention and all of the other facts, as well as the fact that the employee engaged in the agreement and then ultimately agreed would lead the guest to believe that this employee had the authority to act on behalf of the principal. As a result, A would be the most correct answer. Thank you for sitting with us through Bar 10's test prep, lesson number 3. Again, please don't forget to like, subscribe, and ring the notification bell so that you can be updated every time we upload new content. It's our goal to help you prepare as efficiently as possible for this exam.